Hello everyone, welcome to the Public International Law course. In this program, we will continue our course with the International Protection of Human Rights, which is our 8th and final chapter. In this chapter, we will talk about the concept of human rights and ideological approaches, development of international human rights law, human rights and the United Nations system, and regional approaches to the protection of human rights. Let's begin with the concept of human rights and ideological approaches. Despite wide support for human rights, the very meaning of human rights has become contested. Radically different definitions and ideological approaches have been proposed, each of which claims the banner of human rights. However, they are commonly understood as being those rights that are inherent to the individual by the mere fact of being human. Human rights are the basic rights that are essential for the adequate development of human personality and for the happiness of the human society. The idea of basic rights originated from the need to protect the individual against the arbitrary use of state power. Human rights in this category are generally referred to as fundamental freedoms. Although human rights have been classified in a number of different manners, it is important to note that international human rights law stresses that human rights are universal, indivisible, and interrelated. Let's continue on with the development of international human rights law. The concept of human rights dates back to antiquity. One can find reference to rights in many national documents. The first reference of personal liberties is found in Magna Carta of 1215 in England. Other notable references prior to the 19th century are the 1776 Virginia Declaration of Rights and the 1789 French Declaration of the Rights of Man and of the Citizen. The institutionalization of human rights in national documents penetrated into the international system at the end of the 18th century. Prior to the Second World War, persons under the jurisdiction of a state were categorized as either nationals or aliens, but not as individuals. Aliens were protected from state actions under international law, but the treatment of nationals was regarded entirely as a part of the domestic jurisdiction of a state and not regulated by international law. However, in the 19th century, a special exception was made for humanitarian intervention to prevent human rights abuses. Even before the United Nations was created, some treaties had been signed regarding the treatment of minorities. In contrast to the League of Nations, the United Nations has shown a specific interest in the protection of human rights. The events in the 1930s, in which the Jews and other races were subjected to appalling atrocities, led to the increased attention to the rights of the individual. Now we should talk about human rights and the United Nations system. The United Nations Charter does not give a definition of fundamental freedoms and human rights. It also does not provide any machinery to secure their observance. This task has been fulfilled by the subsequent United Nations instruments. The first critical instrument was the Universal Declaration of Human Rights, adopted by the General Assembly on December 10, 1948. It defined expressly certain human rights and fundamental freedoms that need to be protected. The Declaration is not a legally enforceable instrument, and some of the rights mentioned therein could not be said to represent the legal rule. Other rights are merely general principles of law or represent elementary considerations of humanity. The rights enshrined in the Declaration in its 30 articles are broadly divided into civil and political rights and economic, social, and cultural rights. Among the human rights agreements, the most important are the two covenants adopted by the General Assembly in 1966. The International Covenant on Civil and Political Rights and its two optional protocols, and the International Covenant on Economic, Social, and Cultural Rights. These two covenants, optional protocols to the Covenant on Civil and Political Rights and the Universal Declaration on Human Rights, together form the International Bill of Rights. The covenants are treaties that are binding on the parties. They impose legal obligations in respect of those rights and provide machinery for dealing with complaints of violation of the obligations. Before we come to the end, we should mention some of the regional approaches to the protection of human rights. The European Convention for the Protection of Human Rights and Fundamental Freedoms was adopted by the Council of Europe on the 4th of November 1950. It is by far the most established regional human rights treaty whose jurisprudence is well developed. It incorporates mainly the civil and political rights enshrined in the Universal Declaration of Human Rights. The Convention imposes binding commitments on the states parties to enforce and secure to everyone within their jurisdiction the rights and freedoms enlisted in the Convention. The Council of Europe is an organization of European countries. It was founded in 1949 by 10 West European countries. Currently, it has 47 members. It aims to achieve a greater unity between its members for the purpose of safeguarding and realizing the ideals and principles which are their common heritage and facilitating their economic and social progress. Membership is open to all European states who seek harmony, cooperation, good governance, and human rights, accepting the principle of the rule of law, and are able to willing to guarantee democracy, fundamental human rights, and freedoms. The American Convention on Human Rights was signed in 1969 and it entered into force in 1978. It draws upon the 1950 European Convention on Human Rights, the 1948 American Declaration of the Rights and Duties of Man, and 1966 the International Covenant on Civil and Political Rights. The Convention guarantees primarily the civil and political rights. The heads of the Organization of African Unity adopted the African Charter on Human Rights on the 17th of June 1981. The Charter came into effect on the 21st of October 1986. As of 2016, all the 54 member states of the African Union have ratified the Charter. This is the first human rights document that has emphasized the people's rights like the third-generation rights, right to self-determination, right to development, the right to freely dispose of their wealth and natural resources, and so on. The first version of the Arab Charter on Human Rights, or ACHR, was adopted by the League of Arab States in 1994. However, no state ratified it. The revised version of the Charter was adopted by the Council of the League of Arab States on the 22nd of May 2004, and it entered into force on the 16th of March 2008. The Charter draws upon the Universal Declaration of Human Rights, the two International Covenants on Human Rights, and the Cairo Declaration on Human Rights. The Charter contains 53 articles. It includes civil and political rights, as well as the economic, social, and cultural rights. So this is the end of our program, which was the 8th and the final chapter of our Public International Law course. You can always go back and watch our previous episodes. Goodbye.